you know, I agree with that. You can move on.
Okay. Did the public generally know that George Benish was counsel for the water district based on your interactions?
Yes.
Your Honor, I would move to admit Exhibit M, the 2005 agreement.
No objection, Your Honor. It'll be admitted.
The Exhibit I 2008 agreement.
No objection. All right, it's admitted.
And I have no further questions at this time.
Okay, Counsel for the defense, do you have any questions for Mr. Hafen?
Good morning. Could you please turn to Exhibit M, please? Exhibit M is the 2005 agreement that you've been speaking of, is that correct?
Correct.
And it's your testimony that insofar as you are aware, the sole role that Mr. Benish played with respect to the August 10th, 2005 transaction was drafting Exhibit M, is that correct?
Objection, misstates testimony.
You can ask him the question and Mr. Hafen can answer. It's a fair question. Go ahead, Mr. Hafen.
I think as I stated, that was part of his responsibility. He would have done the research to make sure that everything that was represented in here was accurate, truthful. Any research that would have needed to be done to verify that these in fact were the water rights that we were purchasing, those types of things. So there was probably a lot of involvement on Mr. Benish's part.
Well, actually, the word you used was you assumed that Mr. Benish would do some research, isn't that correct? You have no personal knowledge of what Mr. Benish did, correct?
Well, part of what I did as a board member, I would often review billings from Mr. Benish. I was one of probably a few board members that actually asked Mary to bring me the billings when we received them from Mr. Johnson. I would review billings from Mr. Johnson. I believe the question was asked that Mr. Benish was comfortable with this agreement, but I would review the billings to see what Mr. Benish was billing the district for. And I believe that, if I recall, that there was reference to work that was done in accordance with this agreement.
Can we approach the bench, please? Sure. Outside the presence of the witness.
You want me to excuse the witness and talk? Is that what you're saying?
For a minute, maybe.
Okay, well, I'll do that if you want to. Mr. Hazen?
Do you want all of the lawyers to come up, or just the dealing with it? Oh.
Yeah. You guys can just stay where you're at then, right? Mr. Hazen, I'm going to ask you, based upon that request, if you would mind, please just go ahead and step outside the courtroom. Also, when you get a chance, let's get some water up here, okay? Please, witness. Okay, Mr. Hazen is sequestered, so to speak.
Your Honor, I'm seeking a little guidance from the court. Recognizing the one counsel, it's an informal one, you know, generally speaking, the lawyer who's going to question a witness has to make the objections, and I understand that. The last time that we were here, you rightly said, because you are correct, that a hearing of this nature is not strictly bound by the rules of evidence. There have been some objections interposed. Most of them have been to the form of the question. But there are degrees of hearsay that are coming into this record that give me concern. And because of the court's, I don't know that it was necessarily a ruling, but certainly a statement at the end of the last case, and because candidly of my not wanting to unnecessarily either protract this hearing or irritate the court, all right? And that's a valid concern in any courtroom, in any case. I've been sitting here at some point, it's sometimes about ready to pop a heartbeat because of the way that some of this testimony is coming in. All I'm really asking for is, are there types of objections, given that the rules don't apply anyhow?
Well, they're relaxed.
They're relaxed, I understand that, but relaxed really means that they're in the court's discretion. That's what relaxed means, that instead of things being mandated, they are rules if you want them to be, and if you don't want them to be, you don't have to apply. Some of this stuff that's coming in really has the potential for being pure speculation and multiple hearsay. And I think personally, having listened to the direct examination now of two individuals in the opening statement, intended to do something that I know it won't do, because I know you as a jurist, and I know your philosophy, and that is to really inflame these proceedings. To somehow take the position that because a newspaper in a small community is covering a story, and that it's important out there, that it has any bearing whatsoever on the rules or the ruling that you have to make, is perhaps more than I can bear.
Well, the case that your side provided to me and wanted me to consider in conjunction with the Wade case that I felt was the most relevant is Brown versus 8th Judicial District Court. And in that case, the Nevada Supreme Court does tell me that the likelihood of public suspicion or obloquy is important, and that can be established in a certain way.
I
mean,
understand
I will
that,
tell
I
you
don't have a
that
dispute with that.
in this sort of a, I mean, it becomes relevant. A factor is what the public
Okay,
thinks
I
about.
don't have a problem with
Because
that.
it's the appearance of impropriety concern, as I know you well know.
But there are,
So really, the public's interest in this is a relevant factor under the case law. So
I
if somebody
understand.
talks about the newspapers in Mesquite, respectfully, I think it's relevant, because
Well-
that is how the public in Mesquite would receive information.
you still have to lay foundations for questions like the last one, or the one before that was asked with respect to, does the public in general, you have to lay a foundation for that, all right?
Well, as a city councilman in Mesquite,
So what does that mean? That some people that appear before him that are willing to get out of their easy chair?
well, my thought is he represents a constituency in Mesquite, and he's a city councilman, and he's probably cognizant of what the public thinks because he's a city councilman. That's what I think. He
Well, if that's what you
represents
think.
the citizenry of Mesquite.
So I guess to ask it differently, to get back to what I started here, are you saying that you don't want objections to things of that nature because in
No,
your opinion?
I'm not saying that. I mean, anybody can object as they see fit in good faith. That's what we can do. I mean, the rules in an evidentiary hearing, as I know all these veteran practitioners know, are somewhat relaxed and not as formalized as they would be if we were in front of a jury trial, okay? The idea is for me to just receive relevant evidence, and if it's not relevant, I won't receive it. That's pretty much the parameter I give you.
Well, there's a presumption that a bench trial, a judge doesn't consider evidence that's irrelevant, whether it's objected to or not. And I'm assuming that this is very much akin to a bench trial.
Well, I think that's a fair statement of it. I mean, I only consider what I really feel is relevant. I will say that this idea of what the public in Mesquite thinks about things, though a relevant factor, to me it's not the mainline factor to be considered here today. It's a relevant factor, but it's not the mainline factual finding that I'll have to make.
Well, even,
I mean, in other words, I'm ready to make the factual finding that it is important to the Mesquite public. They're well aware of it. It's been publicized. It's important to the water district. And I respect that, and that factor is met. But it's not the only factor to be considered here today.
it would seem to
If
me-
anything, I would just say that any further presentation of evidence having to do with it, is it important to Mr. Bingham's client? Is it important to people in Mesquite? Is it important in general? You don't really have to tell me any more about that. I get it. I mean, believe me, I get it. I
Your
know
Honor, we would have
it's pretty darn
stipulated to
important to
that.
everybody.
We would have
And I respect
stipulated.
that, okay, tremendously. So,
I mean,
I know you would have, but.
I have no doubt that were this taking place in Mesquite, they might lynch me leaving the courtroom, okay? But if we behaved ethically, we have a right to be in this case.
Okay, I understand. That's what we're here to determine today.